The biggest number it ever got to between the end of the Fraser administration and the present is 4,100 people in 1 year. And that was the year that the Tampa episode happened. 4,100 is a tiny number. Why? Well, our geography's probably got a lot to do with it. It's really hard getting here. You've got to be desperate to get here. And then you have this problem. You say, well, let's just take a quota from offshore and that'll be an end of it. But what if people do come here? What if someone is desperate enough, fleeing the Taliban, to come here and say, I'm here on your doorstep, please protect me? Are we going to throw them back to sea, kill them, lock them up forever, pretend they're not human beings? What are we going to do with them? Now, and that's where you come to the crunch point. Are we prepared to acknowledge the force of the international human rights obligations that we've signed up to? I would have thought it was very much part of Australian culture that we would say, yeah, we're fair dinkum when we make those promises, and now we're going to honour them by making them legally effective within this country.
Good point, Julian. And I might say that from my perspective, that if we had have had your charter, or even if we had have had something stronger than that, it wouldn't have stopped the response of the Australian government to the terrorists, alleged terrorist attacks. And there's the American experience of the Patriot Act. Do you want to comment on that?
Yeah, I do. I think the Patriot Act in the United States is a terrible thing, and in fact the United States government reaction to the terrorist attacks on September 11 I think has been catastrophic in many ways, and it's certainly diminished America's standing in the eyes of the world. Let's wind the clock back to just before Tampa, and let's suppose we had the charter of the sort that Frank Brennan has recommended. What would happen then is, first of all, existing laws would have to be interpreted by the courts as far as possible in a way that conforms to the rights recognised by the charter. I'm confident that would have made a difference in the Al-Masri Al-Kateb case. For those of you who are interested, Al-Masri was released by a federal court. In the full federal court, the decision held. It was on its way to the High Court when Mr Al-Masri was able to be returned, and so he left the scene, and in his place, the Al-Kateb case, which had similar facts, was sent up the line to the High Court. So when you hear Al-Kateb, it might just as well have been Al-Masri, and the end decision of the High Court was, yeah, you can lock them up forever. Now, in that case, Justice McHugh, who was the swing vote, has said since he retired that if there had been a Charter of Rights in Australia, he would have felt legally able to decide the opposite way. So that the Al-Kateb decision would have gone the other way if we'd had a Charter of Rights. Pretty important. Next thing, and maybe more important than that, is that because the charter of the sort proposed binds public authorities, which includes government departments, the sort of abuses of human rights that occurred daily in the detention centres would have been susceptible to legal challenge. You would have had a legal toolkit to dip into, to say to the department, you're making women queue up for sanitary pads and receive them from a male nurse. They have to queue up in the sun until they get them. They have to account for how many they use. You know, these are affronts to human dignity, and the Charter would have given them a legal right to have that changed. There are many other aspects of the indignities in detention centres that would have been susceptible to correction, not by litigation, but by simply telling the bureaucracy that they were failing in their obligation to act in a manner consistent with the Charter rights. I think that would have made a great difference. Now, the next area where it would have made a difference, you mentioned the anti-terror legislation, and that's important. The anti-terror legislation, when introduced, would have required the Parliament to say, well, okay, in its present form it's not Charter compliant. So what do we have to do to make it Charter compliant? We have to look at what erosions of rights are reasonably justifiable in a free democratic society. Of course, some infraction, some reduction of rights is justifiable, but not without regard to the benefits to be obtained and the price to be paid. No one in the public arena, no one in the Parliament did the calculations with the anti-terror legislation of saying, oh, by the way, we're trashing people's human rights. All they did was say, this will make you safe. And they didn't look at the human rights consequences at all. They would have had to if we'd had a charter.
Julian was talking a little moment ago about the things that were happening at Woomera. I'll never forget this particular incident where we were talking to a woman who had 3 children, and this was about May of 2001. So the detention centre had been going for 18 months. And the way refugees travel is the men come first and the women and children follow. So a lot of men had come to Australia, been accepted as genuine refugees and living in the community. And this particular instance involved a woman who hadn't seen her husband for a long time, and with her 3 children who were really cross that they hadn't seen their dad, and there was nothing that she could do. Anyway, we were conducting an interview one day and we got the phone, and Paul Boylan dialed the number and got the husband on the phone, and he spoke to his wife, and lots of tears, and from everyone, of course, at this instance. And that was on a Saturday when we all used to go to Woomera, lots of us, people like Claire. And this particular day we sort of said some things to him, and he turned up in my office on Tuesday saying, I want to go and see my family. I haven't seen my family, can you fix it? And then I worked out how it had to be fixed. The system, the government system, was that the person inside had to provide a note and get that to the person who wanted to come and visit, and that person had to produce it at the gate. Quite simple system. But if no one understood the system, no one accessed it. And so that man didn't know, and he didn't, no one told him, and all those who had tried before didn't get and see their families. So eventually we worked it out, told him how it worked, and he went and saw his wife and children. At that time there were 45 women in the same situation with children. That was the sort of things that were happening at Woomera, and I think that was a response to how they perceived the Australian government expected them to treat those people. So that's the problem.
No, and I'm saying that that's exactly the sort of problem that would have been ameliorated rapidly if there had been a charter, because there is no doubt that people running detention centres would qualify as public authorities because of the definition of that term. They're doing it on behalf of the Immigration Department, and they would have been in breach of their obligation to respect, for example, the right to family life and various other provisions. You would have fixed that without even having to go to court. Now, you know, if all a charter ever did in its existence in this country was to get rid of the gross indignities in the treatment of people in detention centres, I reckon that would justify it without anything more.
I'm going to interrupt this quite entertaining debate at this point and open it up to the floor, because I know there's lots of people out here today who have questions about a Bill of Rights, perhaps who have an opinion about a Bill of Rights. We have a couple of roving microphones, I believe. Do we have the roving microphones? Does anyone want to ask some questions of Jeremy, Julian? Fantastic, there's a few people in the middle, if we could. When you do ask your question, I'd ask if you'd just introduce yourself as well. Thank you.
Yes. Thank you. My name is Leslie Lynn. I was living in Canada when the Canadian Charter of Rights and Freedoms was adopted. Listening to the 2 excellent speakers today, I have the impression that what is being proposed for Australia results primarily to people who want to come here. This was different in Canada, I think, and possibly both of you know a great deal more about the workings of the Canadian Charter than the one proposed here. But I just make the point that as soon as this was adopted, every Tom, Dick and Harry came out of the woodwork. The courts, which were already overloaded, became more so. Canada went almost overnight from being the least litigious country in the Western world to the most. Can you comment on this, and could you elaborate? Is what is proposed for Australia going to be for the general community, or is it just for refugees?
Oh no, it would be general. In fact, Frank Brennan's report says explicitly that it should apply to everyone in Australia and people outside Australia who are within Australia's jurisdiction, if that makes any sense. So if you're an Australian in the embassy in London, well then it would apply to you just as if you were here. And it applies to people in Australia, not to Australian people only. So, because, non-Australians are also human. So one of the little sophistications that we're getting, which is very good.